Thank you very much, Pierre and Sylvain, for organizing the venue here. Thank you very much to Jeremiah for organizing the project of the Varsia project. It has been really, as you said, challenging and exciting actually to start working with you on this project. My my paper will be about casual work in Europe, and do we have a problem about casualization of the workforce in Europe, and are we doing something about it, or can we do something about it? Just a quick caveat before I start speaking. I, at the moment, work at the International Labour Office, but I sit here in my very personal capacity, so nothing I say is must be related to the position of the office on this matter. Yeah, you know. Okay. So I actually started analyzing some European instruments and find that there are some exclusions that are possible for casual workers under some important instruments of European employment law. So casual workers can be excluded from the application of the framework agreement on part-time. They can be excluded from the application of the written statement directive. And what I find interesting also is that this exclusion in the written statement directive is very much similar to the exclusion that we find under the European Social Charter. And it also regards people that have a relationship that do not exceed 1 month of employment, or do not exceed 8 hours per week of work. So these people theoretically can be excluded from the application of this directive. Also, international labour standards, so convention and recommendation of the International Labour Organization, in some cases allow for an exclusion of casual workers. Early instruments, such as the one indicated there, allow this exclusion on the condition that it's about casual workers who are not employed for the purpose of the employer's trade of business, so it's not related to the core business of the employer. The termination of employment instruments, so the termination of employment convention and recommendation, and the early recommendation on termination of employment allows exclusion, provided that casual work is for a short period. But actually, in other cases, other exclusions are allowed, and the accompanying recommendation of Weber recommends to include that indeed in the policy also casual workers. The Committee of Minimum Association and Committee of Experts on the application of convention and recommendation, however, clarified that casual workers are to be covered and need to be covered under the 8th Fundamental Convention, because those conventions are universal and apply to all workers, save for, in some cases, very specific exceptions like the armed force and the police for some of the instruments. But this leaves us with a question: what is casual work? What's the definition of casual work? Because we don't have, actually, don't have a common, unequivocal definition of casual work. At least not a legal one. I started a research among developing and developed countries, and, but there's not an unequivocal definition of what casual work is. So I resorted to some non-legal instruments, and the International Classification of Status of Employment, which is a classification for statistical purposes, describe casual workers as those workers who have a relationship which is not expected to continue for more than a short period. There's another interesting definition under the ILO of thesaurus that takes into account occasionality, of course, but intermittence. So casual workers are those workers which work on an intermittent basis. So there's not expectation that the relationship is goes continuously. Sorry, but yeah. So if we then look at these two criteria, we can also include in the analysis those legislation, especially in developing countries, that will daily workers and weekly workers, or workers with very short fixed-term contracts, we can call it that, but they are very, very short in nature, daily, weekly, or hourly contracts. I then went to look at the definition of casual workers in developing countries, and I found that in more than 40 countries there is a statutory definition of casual work. Almost all these countries are developing countries, and there are frequent elements of definition. So they are recurrent: temporality or intermittency, a maximum fixed direction, as the work must be in some cases extraneous to the core business, or the engagement is explicitly daily or hourly or for a pay, which is daily or hourly. The most common approach indeed is to combine two or more of these elements. So this is what we learn about about casual work from the legislation of developing countries. And then we have some example of regulation, which is in some cases a total exclusion from the application of labor law, or a total exclusion which has been repealed presently in some countries. There's a partial or total exemption from dismissal regulation. Normally there are either an exclusion or a specific regulation for annual and weekly leave or pay public leave, or regulation that allow to pay the holiday on a pay-as-you-go basis. So instead of giving actually the holiday, you just pay a premium on the salary without considering actually the period of rest. What's interesting actually in all this regulation is that in some cases they take into account the fact that casual work is defined as being short, is perceived as being short, but actually it can last for a long period. So we have a sort of account of what I call the relationality of casual work. So you can be a casual in the sense that you can be working intermittently for the same employer, but for a long period of time. And in some cases, there are actually regulations that take into account this relationality. So in one sense, there are special criteria for calculating continuity of employment. So we take into account different period of time over a time span. After a period of time of even an intermittent service, you have the right to be converted as a permanent employee. And in some cases also the notice period varies, so the more the relationship lasts, the higher is your notice period. So we basically have a consideration for the fact that casual work it's perceived to be very short, but actually can last for considerable amounts of time. In most of the cases, however, we have a de facto exclusion of casual workers from important employment rights due to the fact that in some countries those employment rights are tied to qualification period or minimum eligibility period, so you need to be employed continuously for a certain amount of time before doing some work. Casual work also exists as a concept in developed economies. We have a casual employment concept, a common law, which is current and it's in Australia, in New Zealand, in Canada, and also in the UK. Courts speak about casual employment, and the characteristic of casual employment are discontinuity again and no commitment. This is important. No commitment to further offer or accept work. Of course, there's also a sort of primacy of fact rule. So, in a sense that if the relationship actually is continuous, then you can ask to be reclassified as a permanent in some cases. In Australia, there's a very specific regulation of casual work in the sense that casual work do not have the right to public holiday, to pay holidays, but they earn the so-called casual loading. So basically, there's a premium on the wage they earn because of the fact they are casual. In the UK, there's a very specific definition of what the mutuality of obligation is. So to classify as an employee and to claim continuous employment, you need to fulfill a very strict test of mutuality of obligation, and then we can discuss that later in the general discussion. And recently we have a statutory definition of 0 hours contract that we will see, if we want in the discussion, that it might not solve all the problems of 0 hour workers in the UK. In many countries in Europe, recently some categories of simplified work were introduced as an alternative to informality with limited protections and for a maximum duration of days or weekly hours. We also have regulation of on-call work in many countries, and they are being strengthened, if I'm not wrong, recently in the Netherlands. So we have default minimum hours. So basically, you don't opt out, you have to offer the worker at least a certain amount of hours. In Germany and Turkey, a minimum notice period for the worker to be bound to accept the call, when they are bound to accept the call, minimum paid hours in case of call, or a maximum duration of number of calls and working days. What do we learn actually from the analysis? Why do we want to focus on the analysis of developing countries when we are here to speak about the EU? Is actually my point is that we have a problem of casual work in Europe, but in some cases we don't call it casual work. But if we look at many of the arrangements that have been introduced recently in Europe, they resemble pretty much the characteristic of casual work in developing countries. So there is this intermittency characteristic. And we have a very big problem in classifying this workforce for statistical purposes. We don't have data, we don't have reliable data on this particular segment of the workforce. And we have a problem of measuring these arrangements in the leximetrics. What is leximetrics? Is the attempt to measure, quantify the rigidity of employment protection legislation, and there have been several cases like the OECD, I think to the employment from OECD, the World Bank, the ILO is doing this, has been doing this recently. The CBR in Cambridge are carrying out a project of leximetrics, and it is very, very difficult actually to measure. No system, as far as I know, is concerned about casual work. Normally, the maximum that is done is to concentrate on atypical work, which are typical, so fixed-term, temporary agency work, part-time, but the very atypical jobs are not captured in this analysis. So we don't have actually very much data on that. We have an issue of casualization that is fostered by technology. So we have the issue of crowd work, and we have the issue of work on demand via apps, so on app like the care-hailing services and all these things. That can also drive informalization, because in some cases it's not clear what's the employment status of the workers on those platforms, so they don't pay a limited amount of social security, there's an issue of taxes, etc. And I think that the trend towards casual work is a broader trend that overlaps with the problems that already face workers in non-standard forms of employment, so in general fixed-term emergency workers. It's not easy to draw a line that's much intersection in this area. We actually can learn something from the experience in developing countries. At least we can try to understand how they tackle the issue. And I think the issue of relationality, so the fact that actually the workers enter into a relationship in which they are not obliged to accept work in the future, or they might not oblige to be accepting work in the future, but actually they feel obliged because otherwise they're not going to be called in the next shift. We have ongoing relationship of casual work on an intermittent basis, and I think one of the possible solutions would be to take into account that and try to have the regulation on continuity of employment that takes into account different shifts. Even if there's a break, then the continuity of employment doesn't take account of the break, but takes account of the works that are carried out actually. So what are the possible options at the EU level? So what tell us what the solutions are. I think the exceptions should be revisited. Those exceptions were thought in a period of time where we didn't have this big problem of casualization. They are now 20 or even almost 30 years old. And we should actually revisit and limit the exception to the original purpose. So, in a sense, again, we could take into account a maximum duration of the overall relationship and take into account continuity of employment also on an intermittent basis. And also, I think we should consider the fixed term directive. I think that in some cases you could consider several assignments and several shifts as separated fixed term contracts, because there is actually no obligation to offer you work in the future after the term has expired, and so this could be an abuse under the fixed term directive of successive fixed term relationship, and this could be explored as an option. And the last thing is the EU is now not launching, they've been already launched the digital agenda. We really need to put employment and labor issues at the heart of the digital agenda, which at the moment they are not the issue of employment and labor law are not at the center of the agenda. We should actually push, because it is also a problem of employment and labor law and employment and stabilization of workers in the area. Thank you very much.